Good afternoon, Judge Koen.
Good afternoon, Chief Justice, and good afternoon to the Commissioners.
Are you comfortable?
I am, thank you.
Thank you. Well, you've been here before, so you are familiar with the terrain.
Thank you.
Good. You hold a BCom and LLB cum laude
That's correct, yes.
degrees and a diploma in arbitration.
Correct?
Your degrees you obtained from the University of Natal.
That's correct.
Okay. You started out as an attorney.
That's correct, yes.
How long were you at the sidebar?
I did the articles for 2 years, and then I practiced as a professional assistant at the firm that I did articles at, which requested me to stay on, and that was for 1987, and then 1988 I started pupillage at the bar.
And you remained at the bar until your elevation to the bench?
That is correct. I practiced as a junior until 1997, then was fortunate to have silk conferred on me, and I practiced as a senior counsel for 8 years until I was elevated to the bench in 1 November 2006.
In the KwaZulu-Natal division of the High Court?
That is correct, yes.
So you've been a judge since 2006?
Yes, from 1 November 2006.
And you have had occasion to act at the Supreme Court of Appeal on a number of occasions?
Yes, I have. I started in 2015 with one particular appeal. I was appointed for 2.5 months for that appeal.
Was that the potato board matter?
That's the potato co-op matter.
Yeah.
With, I think it was 88,000 pages. And I did that part and then returned because of other commitments back to KZN and then back to the SCA from, I think it was 2019.
Okay. I'm not going to ask you about the judgments you have written. You've appeared before this body before, and we know that you are highly regarded as a seasoned judge who has experience in all the aspects of the law, if that is possible.
Thank you.
I just want to comment that something struck me about the comments that have been written by some of the people who commented on your candidature. And it's about your character. You are described, well, the one I found the most touching is where I think it's one of your nominators described you as a fundamentally good human being. And I thought, my goodness, that's the best compliment any human being can ever be paid.
Thank you.
Yeah. You have mentioned certain health issues you suffer from in your questionnaire.
Yes.
But then hastened to reassure us that they are no impediment to the execution of your judicial duties.
Yes. No, in 2010 I had what is commonly referred to as a single bypass procedure, but I have had no problems since then, and I walk extensively, doing Camino walks in excess of 120, 140 days in 6-7 days in Spain, locally in the Cape, and I have no problems with any health issues.
Yeah. You are super fit, in short.
I don't know about that, but
no one who can walk 100 kilometers without being super fit. Okay. All right, thank you. I will leave things here for now and ask Deputy President Zondi to put questions, any questions I might have for you, to you. DP Zondi.
Thank you, Chief Justice. Good afternoon, Judge Koen.
Good afternoon, Judge Zondi.
Okay. First of all, I just want to place on record that from the comments that I have received from the colleagues regarding your stability, no concern was raised. So everybody was supportive of your candidature.
Thank you.
I see that you have been a judge since 2006, is that correct?
That is correct. On the 1st of November, I'll be a judge for 18 years.
Yes. And during that period, while you were at the case and you had an opportunity to preside.
Yes, on numerous occasions.
Okay. So when it comes to presiding over the appeal cases, you do not have a problem?
No, I wouldn't have a problem. As with all courts, we've had a number of senior judges retiring at that level. So from a fairly early point, I was in the top 5 to 6 seniority-wise within that division. And as such, all or virtually all full bench appeals, 2 judges, I'm the senior presiding, and on full court appeals, the 3 judges, I am almost invariably the senior presiding.
I've got no doubt in my mind that you'll be able to assist the presider should you be appointed on a permanent basis at the SAA, and you'll be able to contribute.
Yes, I would certainly like to think I would, by virtue of my experience and particularly the appellate experience, because often perhaps less experienced colleagues don't always appreciate that an appeal is not a new or a re-hearing of the matter. You have to show that there's a misdirection in the judgment of the court or quo. So those kinds of appellate type nuances are important in any appellate court.
All right. Thank you very much, Chief Justice. I've got no further question to Judge Koen.
Thank you very much, Chief Justice. Good afternoon, Judge Koen.
Good afternoon, Commissioner.
You have handled significant criminal cases, including the state vis-a-vis Mtimkulu, as well as the state vis-a-vis Gutier, which involved issues of sentencing and parole.
Yes.
How do you approach the balancing act between public safety, rehabilitation, and fairness to the accused in criminal sentencing? And do you also foresee any areas of criminal law where further development is needed at the appellate level?
I don't foresee anything in the immediate future. Sentencing is a very, very personal issue at one level, in the sense that one must never underestimate the benefit that a trial judge has, being steeped in the atmosphere of the case, as to what an appropriate sentence is. Having said that, at the same time, I'm not suggesting that one shouldn't interfere with a determination of a sentence that is made by a trial judge when it's inappropriate. But it's the normal triad of factors, obviously. One looks at the interests of society, one looks at the nature of the offense, and one looks at the personal circumstances of the accused. It's a balanced exercise. It's one that comes only with a lot of maturity and many, many years on the bench. It is not something that should be taken lightly. You would have, in the judgments that you referred to, the one in particular was a sentence that had been imposed, which came before me and a now retired judge of the SCA, Koen, in respect of the accused had been convicted of sexual impropriety, sexual assault. And the sentence imposed by the trial court, this was a pastor who had abused a situation and a relationship of trust and interfered with a number of young ladies, girls, in fact, that he was counseling. He had received 4 years. The reason I'm telling you the history to this is because my colleague, I was in fact presiding in that matter, and I didn't think there were any grounds to interfere in the sentence. On appeal to the Supreme Court of Appeal, the sentence was changed from one in terms of section 276(1), which is the sentence that we had imposed, in other words, 4 years, and you would qualify for the normal parole after the initial parole period had expired. And it was changed to a 276(1)(I). Now, I is simply it's the same duration of sentence, but it gives a discretion to the Commissioner for Correctional Services to release the particular accused after having served a sixth of the period. I had thought the sentence initially imposed was one that was balanced. It was imposed by a regional magistrate who was steeped in the atmosphere of the case, and having regard to the nature of the offense, and particularly the violence against women and children, I thought the sentence entirely appropriate. But yes, sentencing is a personal issue. It was changed on appeal, and I unreservedly accept that. But to answer your question, do I see things changing in the immediate future? No, I don't. At times, as a trial judge, I can tell you that the provisions of the Criminal Law Amendment Act of 1997, that's the so-called minimum sentence legislation, at times does, I think, fetter a trial judge's or trial magistrate's discretion, perhaps, but we compensate for it and hopefully arriving at a sentence which is fair, allowing for an opportunity for rehabilitation, and then in due course, either for release on parole after a hearing before the parole board, or then in the section 276(1)(I) situation.
No, thank you very much. I don't have any further questions, CJ. Thanks.
Thank you, Commissioner Nsweni. Commissioner Khanyan.
Chief Justice, thank you so much. Good afternoon,
Good afternoon, Commissioner.
Judge Koen. We have a problem in this country, which our president has described as a pandemic emanating from the misanthropic deeds that we see almost on daily basis being committed against women and children. And I'm not saying that you must give a judgment here or your opinion, but the question that I want to ask is, as a citizen of this country, what do these things say about our law in our country? Thank you.
I think a serious consideration in our country when it comes to crime is detection and successful prosecution. I always say that as a judge or a magistrate even, we are prosecutor-driven. The judiciary as such cannot do much other than impose sentences which will hopefully act as a deterrent. But to reduce crime, and particularly also gender-based violence, the solution really lies in a higher level of detection. In other words, not having these high rates of rapes being reported, but only a very small percentage of them going to court. And then obviously, as and when suspects are detained, having been identified through an elaborate and comprehensive detection process, we must look at a higher rate of conviction. But, I can only, as a judge, contribute on that. I can only convict if I'm satisfied that there's evidence beyond a reasonable doubt. Accused persuades me that his version is reasonably possibly true, he's got to walk. He's to be found not guilty because that is what the judicial process requires. So to reduce the amount of crime, I think it lies more at the level of law enforcement, detection, successful prosecution. I hope that answers your question.
Are you satisfied, Commissioner?
Can I have a bite again, Chief Justice? Judge Good, the women of this country have, or let me say the social relations in this country have put women in the in the receiving end for centuries. If you know, we've said they suffered oppression 3 times or more than that
Yes.
by extension. And if we continue to have inhuman acts like these ones, what do they say about our society? Where we now have a constitution that guarantees fundamental human rights to all its citizens, but they continue to suffer, being killed every day, being molested. What is the message that is being communicated or being put across to us as a nation?
No, I think it's a terrible message, and they're being let down. I think the judicial process certainly tries to do what it can. There needs to be, it's an enormous problem. It's not just a judicial problem. It's partly law enforcement problem, but it's also societal values, attitudes towards women, an economic dimension to it. It's a very complex problem without a speedy solution. But that doesn't mean that it shouldn't be worked on constantly, because as you rightly say, fundamental to what our new order since certainly 1994 is a constitutional state. And it's just anathema to have a situation where people are exposed to this level of violence when we have guaranteed rights. But the problem is to realize those rights.
Thank you. Commissioner Hassan?
Thank you very much, CJ. Judge Koen, my name is Fasia Hassan.
Good afternoon, Commissioner.
JSC Commissioner from the National Assembly.
Yes.
I have 2 questions for you. I think let me start and preface the first by saying it's quite clear from reading the paperwork that your experience is not in question. In fact, as reading it, I came across a number of cases that while I was training to be a lawyer, which I never became, there were a number of your cases cited in a number of different textbooks. So I think that's the first important point to mention.
Thank you.
But the question really that I'm interested in are the measures that you might have put in place to contribute towards the empowerment of lawyers as you were coming through the process, and whether any of those types of empowerment also contributed to the transformation of the judiciary and the sector. I'll start with that question, CJ, and then ask the other one because it's unrelated. Thank you.
All right. If I may answer it this way, I think you might have picked up from the answers to my questionnaire that my slant, certainly initial in law, was more academic and lecturing. I started lecturing at the university part-time while I was at the bar. I also lectured every year to the article clerks at the Article Clerks Association as the article clerks were coming through. That was probably for the best part of the 1990s to early in 2000. I maintained right from the time of my start of my pupillage in 1988 an active interest in pupillage and preparing pupils for their bar exams. I lectured the motion court parts thereof, the ethics parts thereof. At the same time also, I did my fair share of having pupils that I trained, that spent time with me. And I'm very, very happy to say, very proud to say, that many of them have done extremely well. You would have seen that the chairman of the bar who nominated me was in fact one of my pupils, Mr. Mtembu SC. Very successful practice. He's acted with me in KZN, sat with me, and he will make a fine judge when he's appointed. Prior to him, the previous chairman, Mr. Naidu SC, Vanessa Naidu, is also one of my pupils. Another pupil was Mr. Nati Mtlati, who ended up, unfortunately I've lost touch with him, but he ended up as the last time I heard, as the Director of Public Prosecutions in the Eastern Cape. I think he's based in Makanda. It wasn't just across racial lines that I had different pupils, also across gender lines. I had a very successful pupil, Rita Nell. Regrettably, she was killed a few years back in a motor collision at Nottingham Road, because she also would have done well. I still, to this day, twice a year, or when the pupils at the local bar reach that stage of their progression, I conduct the moot courts in one of the real courts in the court building, and they come and they address me on motion court matters and appeals and the like. So my involvement in trying to transfer skills, to enrich, to motivate other young practitioners, mainly has been along those lines that I've briefly outlined to you.
Sorry, Chief Justice, I just want to make sure that the candidate answers the right question. If I can just follow up. I think, Judge Koen, when people say, what is your contribution to transformation as an advocate, what they're asking is whether you have brought Black people and women as your juniors.
Okay. I left the bar in 2006. The system of deviling, as it has been expanded upon a lot more by now, was still very much in its infancy. I didn't have much opportunity to do that. In fact, my last year and a half before appointment, I'd been acting and was away from the bar, so I didn't have much opportunity in that respect. But I certainly understand the value of that, and I'm delighted to see that it's being utilized more and more now.
No, sorry. What do you mean you didn't have an opportunity for that? You were a senior counsel for a number of years.
But it wasn't that general that it happened at that stage to involve juniors. Where it was being done then, it was the exception initially in those early years. It was still something that was being built on.
Commissioner Pillay?
Thank you, Chief Justice. Good afternoon, Justice Koen.
Good afternoon, Commissioner.
I do just want to follow up on that, Justice Koen, because I'm a bit concerned that you reduce bringing Black people into matters to deviling. And I think we mustn't conflate the two.
No, sorry. When I use deviling, I use it as an abbreviation for getting the person involved in the matter.
So we're talking about the same thing, bringing juniors onto your matter to
Yes.
substantively assist you in your matters.
That's right.
And you're saying you never did that?
I can't recall having done that. I might very well have, it's 18 years plus back, have involved in the preparation of some matters, pupils or then very junior practitioners who had just started at the bar. But if you had to ask me which particular case number, I can't remember it then.
Thank you, Chief Justice.
Is the follow-up question? You already had your
It's
your
my
quota.
second question.
Oh, you asked one? Okay.
Yes.
You can ask your second question.
Thank you, CJ. I wanted to separate it because they were different matters. Thanks, CJ. I'll try and be fast because I am aware of time. And I'll caveat my question by saying I have read the transcript of the May interviews. Of course, I was not a JSC commissioner then, but there are some questions I think are important, at least for our conscience to ask, so that when we deliberate later, we just have a full understanding. Judge Koen, I'm very interested in your thoughts around how the judiciary deals with Stalingrad tactics in attempt to circumvent, let's say, justice more broadly. I understand and I've read everything else, but I'm very interested around that. And I'm also very interested, at the time of that previous interview, you had the S versus Mhlongo case. I'm also just interested in the status of that. But more importantly, some of your views on the Stalingrad tactics and the wastage of money and time, and of course the role the judiciary plays, in some ways the last line of fire, so to speak. Thank you.
Yes, the two parts, I'll deal with the easy one first. S versus Mhlongo that I referred to was a, a part of a trial which was disposed of, sentenced, and the accused elected not to bring an application for leave to appeal. So I beg your pardon, that's done, and it's water under the bridge, so that's finalized. Stalingrad is a topic on its own. Stalingrad, lawfare, all those different procedures that are often resorted to by people who either want to eliminate opposition through lawfare, for example, litigate if you've got the deeper pocket, and just make it impossible for the other person to sustain opposition, or then Stalingrad really being a phrase that's been coined to also to avoid the end result by introducing all kinds of interlocutories or procedures. The primary problem, I think, with Stalingrad is the question of availability of appeals. As long as there are appeals and a person has a right in law to appeal, then it's very difficult to close the doors and say, well, it's got to stop here, unless you can show that it is clearly mala fide or an abuse of process. But that is not something in our constitutional dispensation that I think a court should lightly conclude. So the opportunity for a court to say, yes, Section 18(1) of the Superior Courts Act provides that you can appeal, but I'm going to deny you that appeal. I'm going to conclude that what you are doing is in fact mala fide, that it is it's an abuse of court process, is not a conclusion to which a court can lightly come. I'm not saying that it's always impossible, but it certainly normally will involve a number of initial procedures or appeals, firstly being entertained, unless there's clear evidence to the contrary. So it's difficult for, the answer or the expected solution might be, well, this is just an abuse of process. The principle is easy. To find the application of the facts is difficult. So it's not always as easy to quell those things, but there might, as it develops, because our law permits a number of appeals at different stages, and perhaps in due course the Law Commission or the Law Reform might look at limiting the number of stages of appeal that are available. I did just a rough calculation the other day. In an appeal from like a regional court, one can end up with a situation where almost, I think, 18 judges eventually, taking it every step through the appeal process, would have considered that appeal, and it would have gone through something like 6 or 7 stages, all with delays. So it's a combination. I don't think I can give you the answer. There's no simple answer. I can't just say to you, well, there's the solution. It's a lot more encompassing than that. But it's something that should be perhaps considered. Well, not perhaps, should be considered.
Commissioner Breitenbach.
Thank you, Chief Justice. Good afternoon, Judge.
Good afternoon, Breitenbach.
So following on from the previous question and dealing with stolen great tactics, particularly in criminal matters, do you not think that what's required is a little more boldness from the bench?
Yes, it can involve more boldness. Well, when I say boldness, I'd hate to equate boldness to a sort of a recklessness, if that is the imputation. I'm very happy to say that the test remains the same, and perhaps the more consideration must be given when applying the test. But to me, the problem lies with, even if, using the term boldness, even if application for leave to appeal is refused, there's another step that's available. And there's another step available if that's refused. And you can go right up to the Constitutional Court. And the Constitutional Court judgment can be taken an application can be brought for it to be rescinded. And that's really only when we get to the ceiling. So what I'm saying is that perhaps the solution lies in reducing the number of stages that might be available to a disgruntled accused who's been convicted. Because after all, what we're looking at as laws, as a system of rules, it's a system of rules that society subscribes to in order to ensure that there's orderliness. It doesn't necessarily always arrive at the right conclusion, but one needs to have a process, a procedure, where if there's a fault that is made, a mistake, or a misdirection at one level, that there's a stage to correct it. But perhaps the solution lies in getting to a point and saying, if you reach that point, your appeal's final.
Okay, I go along with you on that. What I had in mind more was during the course of a criminal trial, all of these interlocutories, all of these applications for review, and the bench seems to just, for want of a better word, cave every time. And so criminal matters run on for years and years and years, and there's absolutely no reason. If the bench, in my humble view, was a little more bold, then you could not get away with that kind of behavior. That's more of the question I'd like answered.
Yeah, I think the answer lies, or the answer to your question perhaps, in what criteria are taken into account. As the law stands at the moment, judges apply those criteria in accordance with their oath of office. And where they've granted leave, I believe they would not have done so if they weren't required by their oath of office and the application of the legal principles to do so.
I have one more question, please, Chief Justice.
Okay.
Judge Koen, I'd like to revisit the issue of the recusal in the Zuma matter.
Yes.
I know it was flogged almost to death the last time. But you actually got it right. I mean, you got the law right. All your decisions in that matter were right, and you were vindicated in every court thereafter.
Yes,
And so,
the
in
very
retrospect, with
Sorry.
the luxury of an armchair view, which I understand is a luxury, would you perhaps decide differently in that matter today? Would you still recuse yourself, bearing in mind that the recusal has set that case back 3 years, a case that's already 20 plus years old?
Well, with respect, I take issue on the last statement. Another judge was appointed shortly thereafter, and the delays that have ensued have not been because of the recusal. He could have proceeded and dealt with it. He had his reasons. He had things that were placed before him. There was a full court application, I beg your pardon, the full court hearing regarding the private prosecution, as you know. And interestingly enough, the very grounds that I had raised, that I said would place me in a position that I couldn't see my way out other than to recuse myself, were in fact the very grounds that were advanced in argument before the full court. They were rejected by the full court, but nevertheless, at the time when the recusal was being dealt with, they were findings that had been made. And in those circumstances, a person in the position of the accused, having to argue the points that came before the full court, eventually would have said, well, I cannot proceed before this judge because he's already firmly disclosed what he thought about my arguments. But I accept that recusal is a personal matter. It's personal in the sense of it involves a lot of conscience too. Courts will differ on it. People will differ on it. But at the end of the day, it's the importance of the judicial process remaining intact and being respected. Thank you.
In the 18 years you've been a judge, how many times have you recused yourself from a matter?
Once, this one.
Okay. Commissioner Trolley?
Thank you, Chief Justice. Judge Koen, at the start of the interview, the Chief Justice conveyed some compliments from colleagues and that described you as a fundamentally good person. And understandably, you showed appreciation for those compliments.
Thank you.
Ironically, the former Chief Justice Mogoeng had some less than complimentary comments to make about your character and said, quote, if I've got the quote right, he wondered how you'd been made a judge in the first place. How did that make you feel?
No, I dealt with that at the second time that I came before this body, and I said it left me gutted. I couldn't believe that it was said. And I don't want to delay you or this commission today. The Bar Council and KZN and the Society of Advocates all came out with press releases. The meeting to which the former Chief Justice Mogoeng referred, a judges' meeting, had in fact been recorded. The recordal transcript was circulated. It came into the possession also of the press, and the reports at the time were that he had mistaken me for another judge. And as I said at the second time, the first time after that I appeared, and in fact Justice Meyer was presiding, I said that I accepted that a mistake was made, that I had been mistaken for somebody else, because number one, it is not my character. Number two, the transcript of that meeting where I was alleged to have acted in such a way showed the contrary. And I was not going to, it's water under the bridge, we must move on in life.
Any more questions, colleagues? Commissioner Mangan?
Thank you, Chief Justice. Good afternoon, Judge.
Good afternoon.
Yes. I just want to converse with you the aspect relating to the transfer of skills. You were asked questions in relation to the period when you were the silk, about the transfer, your engagement with black female advocates at the bar. Am I not audible?
Yeah, no, that's fine.
Okay. Now, you said you can't recall, and I accept that. But then I need to ask you questions relating to the time that you were a judge. In the 18 years that you have been a judge, what programs have you engaged yourself in, alone or together with other judges, to train young and aspirant judges, either in your division or through Sajay?
Sajay is by invitation. I haven't been asked. I've been approached at a conference this year in Durban by a person who asked whether I would consider making myself available, and I said I would. Apart from that, we have meetings of judges in our division, and from time to time, the last one that I can recall now, dealt with preparation of for a large opposed motion, and we have a lunch as judges on a Thursday, and once we've had the lunch, I would then address all those present, which will be acting judges, the whole spectrum of junior judges, even up to senior judges, about how I go about preparing and what I do in my preparation, with the intention, that's the reason why our judge president has that, to to impart and transfer skills to the more junior colleagues and those acting who have aspirations to apply.
Now, that's encouraging, but you'd also accept that you do not need any authority to initiate certain programs, more especially when you need to train other people in your division. All what you need would be a proper coordination with your JP.
Yes.
That there is this program that you want to run and run it past her.
Yes. Yeah, no. She governs and manages this. And whenever I'm asked, I'm more than willing to participate in it. You know, we're not as judges in a position of, as much as there's seniority, of me prescribing to junior colleagues how to go about things. The principle is primus inter pares, all the same. If I had to say to you as a junior judge, you must come, I'm giving training this afternoon, it might be taken as offensive, because that judge has standing as much as I have with 18 years. Whether you've got 18 days or whether you've got 18 years, you're a judge. So it has to be organized, I think, also just from orderliness, from a central position.
Fair enough, and that's all, CJ, except that I can compliment Judge Koen on the judgment that he delivered on the 1st of October on the appealability of interim orders.
Oh, I see, the shipping matter,
yes.
MV Smart.
Yes.
Yeah, that's just been handed down in the Supreme Court of Appeal. Yes.
Yeah, it's a beautiful
Indeed.
judgment.
Thank you.
That was not a question, Commissioner. Commissioner Marumokhai, do you have questions for the candidate?
Yes, I have more of a comment, CJ.
We allow only questions, Commissioner.
I will frame it as a question.
Okay.
Thank you very much, CJ. Judge Koen, I think, well, I'm concerned about the transformative issue, but I will leave it at that because it has already been done. I want to deal with this recusal issue. I hear often when people are talking about recusal, and my question is, when one looks at how you dealt with the issue of recusal and how you applied the test of recusal in Zarfu and other cases, did you apply it correctly or incorrectly? That's the question. But nonetheless, I just want to say this after having posed the question. I think an impression should not be created that judges should not recuse themselves. Because the debate seems to be that judges should only recuse themselves in circumstances, which might be true. But I just want to ask you, do you feel like in your judgment, you applied the test for recusal correctly? Thank you very much.
Yes, the short answer is yes, for the reasons I've given in the judgment. And I certainly would not have taken the step of recusing myself had I not concluded that that was inevitable.
And in my view, you were correct. Actually, I agree with your approach and your reasoning. Thank you very much, CJ.
Thank you.
Thank you, Prof. Judge Koen, it looks like we have reached the end of your interview. I don't see any further hands.
Thank you, Chief Justice.
Thank you for not giving up on this process and coming back to subject yourself to our questioning.
Yes.
I wish you all the best. You're
Yes, thank
excused.
you. No, I thrive on the work at the SCA, and I feel I can make a contribution, and that is what has brought me back. But obviously, there would be an end one day to that as well.
Yeah. No, thank you so much.
Thank you.